Helena Silverstein wrote what has received just overwhelming critical support as a book. She wrote this book called "Girls on the Stand," and it's about what the book seeks to do is to dismantle the belief that the compromise that the pro-choice people had come to with the pro-life crowd, where there was a judicial bypass process, is a good compromise. And one of the key areas that it focuses on so far is the difference between our expectations that the law, about the judicial bypass, and how the law is actually implemented in practice in these courtrooms. And she really mounted what was a tour force against it. And you read the book and it's just absolutely scathing, in what it talks about and all of this. And I really couldn't recommend the book to the pro-choice crowd enough and everything, because of this area of minor disagreement with a lot of other people who are nonetheless pro-choice on this issue. Now, there are some quotes and everything from the legal system that you need to be aware of. For instance, in Judicial Policies by Bradley C. Cannon and Charles A. Johnson, trial courts may ignore precedents quite often, especially misdemeanor courts where appeals are rare. Indeed, such judges may not even be aware of relevant precedents. Ignorance of the law among judges and judicial gatekeepers stands between minors and their access to bypass hearings. This ignorance is substantially at odds with what imagines the bypass process will provide. While we found widespread familiarity with the provisions of the bypass among the Department of Children's Services, DCH, court advocates in Tennessee, the same cannot be said of the courts. Indeed, respondents in 40% of Alabama's courts and just over 45% of Tennessee's courts and a whopping 73% of Pennsylvania courts proved inadequately acquainted with their responsibilities under the law. We encountered a continuum of ignorance during our contacts with the courts and DCH advocates. Some respondents categorically denied the availability of the bypass options. Others expressed a complete lack of knowledge or a substantial uncertainty about the possibility of avoiding parental consent through a bypass system. Still, others communicated specifics about the process, but provided misinformation about certain essential features. In this chapter, I detail these ill-informed responses. I also recount the manifest opposition to abortion and the bypass options that is sometimes accompanied them. Most of the ignorant responses we encountered came from court employees who doubted the existence or knew next to nothing about the bypass option. Of the 222 county courts charged with handling bypass petitions in Alabama, Pennsylvania, and Tennessee, 100 demonstrated substantial or complete ignorance about the bypass system, or worse, expressed considerable doubt about its existence. These include 22 of the 67 county courts in Alabama, 41 of the judicial districts in Pennsylvania, 37 of the 97 courts in Tennessee, and more often than not, these courts answered our inquiries by referring us to third parties absent any knowledge of whether these parties would be helpful. In some instances, respondents simply had nothing to offer. You're going to have to call a lawyer. As discussed in Chapter 2, the Supreme Court has not explicitly required states to give minors the right to court-appointed counsel in judicial bypass proceedings, but many states, including Alabama, Pennsylvania, and Tennessee, have extended this right and notably have undertaken an obligation to tell minors about it. Nevertheless, many courts failed to demonstrate awareness of this or any other obligation under their state's consent statute. Contacts with courts frequently yielded no insight into the bypass process, but instead generated a perhaps well-meaning but in any case uninformed recommendation that a minor secure the services of a private or legal aid attorney. This was the most common piece of advice we received from the respondents who proved unfamiliar with the bypass option. The recommendations to contact an attorney was usually accompanied by candid expressions of ignorance about the law. As juvenile court officer said in a typical fashion, I have no idea. You'll have to check with an attorney. The Tennessee court employee remarked, honey, I have no idea. Have you called an attorney? I have no earthly idea, admitted another Tennessee respondent before suggesting consultation with an attorney. In Pennsylvania, an employee in the judge's chamber said, woo, I wouldn't know how to tell you that. She would need a lawyer. You can't just go to the judge and have the judge deal with it. When confronted with these suggestions, we pressed for further information about how to secure an attorney. Respondents often declined to offer guidance and sometimes explaining the legal obligations to avoid attorney referrals. And as an employee in an Alabama's court judge's office stated, I can't give you an attorney's name. It's unethical. It would look like we were trying to recommend a particular attorney. In other instances, respondents offered no explanation. One Tennessee respondent simply said, you have to go through an attorney. I'm sorry, I can't recommend any. A Pennsylvania court employee said before abruptly hanging up, you would have to call an attorney. Whereas some respondents were plainly reluctant to provide even the most minimal guidance on how to obtain legal services, others tried to offer some general direction. When pressed for further information about counsel, sometimes recommended to look in the yellow pages. As an Alabama court employee said, you'd have to look in the phone book under attorneys and decide which one you would want to ask. Some uninformed respondents suggested and sometimes provided phone numbers for lawyer referral services, agencies that match potential clients with private attorneys. Others directed us to the State Bar Association. These suggestions came without accompanying comments about the conditions under which court-appointed counsel would be provided or under any other information about the bypass process. Following these leads ended with the prospect of hiring a private attorney. One lawyer referral agency mentioned by a Pennsylvania court said, I can refer you to a family planning attorney, but I don't know who would be able to help you deal with that. I'd have to take her name and address, or at least her name, and refer her to a lawyer. But I don't know how I could. I don't know who could help without charging anything. The Pennsylvania Our Association described their referral services this way. We would set an appointment with you for an attorney that handles these cases. There would be a $30 to $75 fee payable to the attorney at the time of your appointment. Should there be any other fees, this would be between yourself and the attorney. The respondent also suggested to call legal aid, but counseled they may not deal with that type of matter because they don't take everything. The Pennsylvania Bar Association was not alone in directing us to legal aid, with several court employees directed us in this way, anticipating that legal aid organizations would provide counsel free of charge. Take the following exchange with an Alabama court employee. I think that's going to have to be a court case, but I don't know. I've never had one. Hold on a minute. You're going to have to call a lawyer. I called the judge's office. They said you need a lawyer. Is there anyone you can recommend? I can't recommend a lawyer. I'm legally bound not to recommend a lawyer. You'll just have to pick one and call one. Would you have a girl? Would a girl have to pay for that lawyer? I honestly don't know. You'd have to call one and ask. We've never had one of these. You might call legal services. Just call your lawyer first and see if it's going to cost anything. And then if it is, call legal services. Those who recommended calling legal aid often indicated some measure of appreciation for the financial burdens minors might face. Nonetheless, federal law bars legal organizations that receive federal funds from handling abortion-related cases. Referrals to legal aid therefore turn out to be dead ends, as the following responses from the Tennessee Legal Services illustrates. We do not do that here. I don't know how you would go about doing that. I don't know what the law is. I'm thinking you're under 18. Your parents would have to authorize that. Likewise, legal services employee in one Alabama county said sympathetically, I'm sorry, our office is prohibited by federal regulations from giving advice on abortion. She would have to contact some other attorney on that. I'm real sorry. Judges were among those who failed to indicate that the minors have a right to court-appointed counsel and instead recommended securing a private attorney. A Pennsylvania judge who proved barely knowledgeable about the bypass option said, in response to our inquiry, well, the act was challenged in federal court, and I'm not sure where it stands now. It may still be on appeal. You might want to talk to a lawyer. Under the act, you have to file a petition, so you need a lawyer. In Tennessee, the judge explained, I've never done it. I'm going to have to give you another number to call. It's lawyers that will do work without charging. And another Tennessee court, a judge said, the judge told me to give you the number for legal services. These attorneys there can help you. You're going to have something written up for the judge to sign, and I don't know what that is. The judge doesn't know what that is, so you're going to have to talk to an attorney And I said I hated to send you to an attorney. That I said I hated to send you to the attorney. So the judge said to give you legal services. They have attorneys who don't cost anything. Like their counterparts in Tennessee and Pennsylvania, some Alabama judges exhibited their limited acquaintance with the bypass process. One juvenile court judge offered this rather candid response: I don't know how to help you. I've been doing this for 17 years and I've never had one of these cases. These provisions about that and our recent court decisions, but I'm not well versed enough to advise you about it. I could say that there are three places that you might contact. One is your physician, two is a lawyer, and three is the Department of Human Services. Maybe if you look in the blue pages. Why the recommendation to speak with an attorney was the most common response given by court personnel who proved ill-informed about the bypass process. Other third parties were also named as potential sources of assistance as respondents flailed about for answers. Many respondents recommended contacting private organizations that deal with abortion or pregnancy, such as abortion clinics, family planning organizations, crisis pregnancy centers, pregnancy hotlines, adoption agencies, and hospitals. Others suggested a government social service agency like the Health Department or the Human Services might prove useful. Court employees who rendered such advice, like those who recommended speaking with an attorney, were typically frank about their lack of familiarity with the bypass options. One Tennessee respondent said, "Ma'am, I don't really know who to refer you to. We don't have any papers in this office with any authority to do that here, so I don't know who can put you in touch with. The only thing I can suggest is that you call Families in Crisis." In another Tennessee court contact case, I have no idea. I don't think anyone in our office knows that kind of thing. I've never had to call anybody to call to ask that question. There may be somebody in the health department you could talk to, but I don't know. In Alabama, a court employee first recommended to call the health department before saying, "I don't know where this is going to get you, but here are some numbers: Planned Parenthood, family planning, pregnancy hotline. Some of those numbers may help you." Similarly, a Pennsylvania court offered a candid response: "I don't have any knowledge in that area at all. Planned Parenthood may have some alternatives to offer you if you look in the blue pages or look for some things. Hang on, let me look. Crisis Pregnancy Center, or you may even call family planning or something. How about Catholic Charities? They offer confidentiality, family planning, the Agency Reproductive Health Center. Other than that, I honestly don't know." Some respondents who made referrals to abortion clinic, the health department, or the like, did so while expressing skepticism that such a thing as a bypass option exists. In Alabama, for instance, one respondent had said, "She cannot go before the judge to get that done. Call information. Just ask for an abortion clinic in Montgomery, and ask them at what age a person has to be, and when that can happen. I'm almost positive you're going to have someone there who is over 18. I'm going to give you the number of the Planned Parenthood, and if they say that you need a parental approval, then you're going to have parental approval, because I don't think a judge can order an abortion." With the exception of abortion clinic and family planning organizations, following up on the many referrals offered by court personnel did not generate accurate information about bypass proceedings. Government health departments and human services agencies, including Tennessee's and DCH's, were of little use in offering guidances, as the following response from one of Alabama County's health department illustrates: "Ma'am, we don't do that, and we're not authorized to give that information out about abortion clinics. We're not allowed because we're not supposed to be for abortion." The crisis pregnancy centers and hotlines to which we were referred were similarly unhelpful. Each is a pro-life organization, and most, including places such as Birthright, We Care, Concern, Save a Life, and Action for Lioness, are Christian ministries. And upon contacting these organizations, we kind of responded like, "We are pro-life, we're pro-life, we don't have anything to do with abortion, that's not our field at all. We help girls have their babies." Only in the case of referrals to abortion clinics and family planning organizations did we come across useful information. In Pennsylvania, of the abortion clinics, not only exhibit familiarity with the bypass proceedings, but also stand ready to guide minors through the petition process. In Tennessee and Alabama, most abortion clinics know about the bypass option and make referrals to the courts. Or in Tennessee, court advocates, as one Alabama abortion provider explained, "I give minors the information where they can call and talk to an intake officer in this county, and I tell them they may have to do it in their home counties. Some of the counties will have judges that will give them that service. I encourage them to check it out." Still, not all abortion clinics and family planning organizations assist minors with the bypass route, as this exchange with the Tennessee abortion provider illustrates. abortion provider, they have to have parental consent unless they can get a judicial bypass to consent since a judge to waive consent. Do you know how to do that? The researcher asked. I don't know how. You'd have to call a lawyer. Just call a lawyer and tell them that you want to find out how to get a judicial bypass for abortion. Other clinics and family planning organizations asserted that the bypass process option did not exist. In Tennessee, one abortion provider said that this option was that this being asked whether an alternative to parental consent exists. No, not here, not without her parents, not in Tennessee. A Planned Parenthood affiliate in Tennessee made a similar comment on this state. You'd have to go to another state. She can contact neighboring states. In a handful of instances, court employees pointed not to third parties, but rather to strategies that would result in circumvention of the parental consent requirement. In each instance, respondents denied that judges have the legal authority to waive parental consent. Two respondents mentioned the possibility of gaining emancipation from parents in the state of Alabama. One respondent said they're required to have their parents' permission. If she's a minor, the judge could do that. If she's emancipated, that's a different thing. Another Alabama employee said there's no such thing, ma'am, not through our court system. The only way you can do that is to file papers to the court to be declared an adult, and your parents would have to be notified about that. I'm sorry, there's not any such thing. In Pennsylvania, one respondent suggested that securing an abortion out of state, she can contact neighboring states to see if they don't have parental consent laws. New Jersey doesn't, New York doesn't. Pressed about the possibility of going before a judge in Pennsylvania, this employee replied, well, that would mean that you would have to go before a judge. Your parents will have to be notified, and you'll have to still be considered a minor. You'll have to be represented, so your parents will have to be there. I think someone has misled you on that one. While a large majority of respondents who proved uninformed about the bypass process rendered some advice about how to proceed, some respondents offered nothing more than doubt about its existence. Several such respondents unequivocally rejected the existence of the bypass option. I talked with our juvenile court judge, an Alabama respondent said, and they said there was no longer a law and that they could no longer do that. Several Tennessee court employees expressed similar assurance in denying that judges may authorize a waiver of consent, offering things like, I talked to the judge, and he cannot do that without your parents' consent. Without your parents' consent, there's no way that you could do that. And you would need to talk to your doctor or with your parents. The judge can't give you permission. No further advice was forthcoming from these respondents. Other respondents were more equivocal, but still at the impression that avoiding parental involvement would be out of the question. For example, a court employee in Alabama said, I have no idea, ma'am. I don't know if a judge gives permission like that or not. We've never had a case like that. I don't want to get you to get your hopes up. I don't think the court would give permission. Similarly, a Tennessee respondent said, I doubt that could happen if you're under 18. Such respondents sometimes endeavored to explain why it would not be possible to avoid parental involvement, as did the following Tennessee court employee. I've never heard of our judge doing that, especially to avoid telling her parents. We don't even allow kids to be in court without their parents being with them. So I know we couldn't do that. I think someone has misled you on that one. I don't think anyone anywhere in the state would do that without a parent. I don't think it's steering you wrong to tell you that. It would see your parent would have to be to sign the papers. A judge wouldn't touch that with a 10-foot pole. So I think she'd have to tell her parents. So here you go. You have the compromise is being systematically dismantled by this author. You know, she's showing you that the bypass option is a bad system. She's doing a brilliant case of it too, just showing you that, you know, there are reasons to oppose even the compromise bills that have allowed abused minors to seek a judicial bypass. This is why I am ultimately against literally parental notification and consent laws and, you know, all of these barriers to access. You know, it explains my opposition because, you know, there's a vast difference between the law saying one thing and that law actually implementing the law and enforcing the law, you know, in a coherent fashion. Unfortunately, our legal system has been proven woefully inadequate to actually enforce the laws on the books when it comes to this supposed compromise. Material errors. The respondents so far discussed in this chapter came from respondents who seem to be completely or largely unaware that such a thing as a judicial bypass process exists. On other occasions, respondents showed familiarity with some but not all features of the law. As I suggest in Chapter 3, certain types of errors and omissions are tolerable when they would not discourage a minor from continued pursuit of a bypass. However, errors and omissions can materially damage the propriety of an otherwise appropriate response. 14 courts, 4 in Alabama, 3 in Pennsylvania, and 7 in Tennessee communicated specifics about the bypass process, but proved misinformation about what I take to be certain essential features. Consider the following exchange with an Alabama court employee. Researcher. I'm calling to find out how a girl who's 18 who wants an abortion can get a judge's permission to avoid telling her parents. Court employee. I would need to set up an appointment and have her come in. Researcher. I'm calling to follow down information about how the process works. Court employee. Come in, see me, and make an appointment. But researcher, could you tell me what she would have to do? Like, does she need a lawyer? I would tell her that when she came in, but it would be best for her to talk to her lawyer first. Researcher, would it go on her permanent record? CE, it would be in the computer. Yes, ma'am. Researcher, how long would it take? Court employee, I have no idea. Researcher, does she need to bring in anything at all? Some form of ID and all? The employee made the bypass process appear to be something that it is not, saying that there would be best for the minor to talk to an lawyer before coming into the court for further information implies that the minor, whether indigent or not, would bear responsibility for obtaining and paying for an attorney. Absent any reference or demonstrable sensitivity to confidentiality, saying that the record would be in the computer and that the minor would have to provide identification suggests that the documentation of the hearing would be public information. Finally, this respondent gave no hint of the need to act with haste. While this respondent made 3 errors, what matters is not the number of errors, but whether the error in combination of errors would likely hinder a minor's pursuit of the bypass option. Misinformation about the availability of court-appointed counsel is an error that by itself materially affects a minor's pursuit of a bypass. As the U.S. Court of Appeals for the 7th Circuit has pointed out, minors are particularly susceptible to intimidation and confusion when confronting the legal system. When respondents fail to acknowledge that they are navigating navigating the bypass process, the minor is entitled to and will be afforded the guidance for an attorney, or in Tennessee, a DCS advocate. They portray the bypass as a road the minor must travel alone and risk sacrificing the minor's rights to her own vulnerability. We encountered this sort of error in several instances when court respondents clearly knew about the bypass option, as the following exchange with an Alabama judge illustrates. Judge, you need to talk to an attorney and have the attorney file the appropriate petition in the court to get permission to not tell the parents. Researcher, how would she go about getting an attorney? Judge, she would walk into an attorney's office and tell them what she wants to get done. Researcher, so it would cost money? Judge, well, some attorneys will take a case like this without a fee, others will require a fee. If you're unable to hire an attorney that is engaged in private practice, you might consider talking with someone in legal aid or the Bar Association's volunteer lawyer program. I'll give you a few hints on how to contact the Bar Association. Call information for Montgomery. Ask them to give you the number for the Alabama State Bar. They'll give you the name of the attorneys in this general area who have volunteered to represent people who have no money. Likewise, the Alabama court employee who communicated some awareness of the bypass option could not say whether the court would make counsel available to the minor. Court employee, she's going to have to come. She's going to have some way to get an attorney, do a survey, do a petition to the judge. Then if the judge consents, he'll hold a private court session and have to sign the petition to have it done. But she's going to have some way or another to have an attorney. We have attorneys here. We have an attorney here Tuesday and Thursday. Researcher, would the girl have to pay for the attorney? Court employee, I don't know. If she does, it may not be that much, but she might not charge you. You would have to make an appointment to see him, to talk to him. You can give him a call to make an appointment to see him. In these exchanges, the suggestions put forward by the respondents led to the prospect of hiring and paying for a private attorney. Despite the judge's hints, contacting the Alabama Bar Association did not yield access to a volunteer lawyer. The Alabama court employee's recommendation that we speak to a particular employee proved no more helpful. The attorney did not explain that the court would pay for counsel if the minor could not afford to do so, or that she is entitled to file a petition without paying a fee. They said instead that you have to file a lawsuit, you do it anonymously, and you ask the judge for a court hearing, and the judge reviews it, makes a determination based on the facts. The court costs are $154. Attorney fees are about $400. So you're talking about $550. On other occasions, court employees omitted mention of counsel and simply suggested that the minor would bear the burden of initiating the proceedings. In one Pennsylvania court, a woman in the judge's process chambers literally explained it this way. We do have something in our local rules of court. What we need to be done is you need to file a petition with the court, and the local rules outline what needs to be in the petition. We have done it. We have this in our law library. If you come in and look at it, then you would know what the procedure is. We don't have a form to fill out, so you would need to create the petition yourself and put in the information that they have in the local rules. You may need to get additional information once you see what needs to be in the petition. Asked if anyone would be available to help with the petition, the respondents did not disclose the court's obligation under the law to provide legal representation. She said, referring to those who work with the library, they can't actually help you with the petition. We can lead you to the local rules and you can make copies, but that's it. Misinformation about counsel was not the only notable error that encountered among respondents who exhibited knowledge of the bypass alternative. A number of courts were unaware of their responsibility to preside over hearings, even while able to recount details of the process. For example, a juvenile court officer in Alabama elaborated that some of the key features of the bypass proceedings, including the availability of court-appointed counsel, confidentiality requirements, and the need to move the process along quickly. The officer nonetheless went on to say, my understanding from one of the larger counties that has in fact done these is that it needs to be done in this county, and with that the abortion procedure needs to be done in. It needs to be filed in the county that the clinic is in. A respondent in one Pennsylvania court made a similar comment. It's been a long time since we've done one of these. I don't know if it can be done in this county anymore because we don't have a clinic in this county. These responses fail to acknowledge the minor's right to petition for the bypass in her home county, a right created by states in order to spare minors from some of the burdens of travel. The creation of this right is an implicit recognition that forcing minors to travel perhaps great distances for a bypass proceeding is a tantamount to offering no hearing at all. At this time, the research was conducted. The brochure was distributed by DCS, listed contact information for 28 advocates assigned to serve Tennessee's 95 counties. 5 of these advocates proved to be unavailable, as a matter I take up in Chapter 5. One of the remaining 23, none demonstrated a level of ignorance we found among many court employees. Indeed, 22 advocates produced acceptable responses of the sort discussed in Chapter 3. One, however, made material errors in conveying information about the bypass process. This advocate, who serves 7 counties, began by noting correctly that the minor would have to file a petition in the court in order to obtain the judge's consent for an abortion. She also indicated that the petition process would be cost-free and that it would not take long. However, the advocate said the minor would have to consult her parents. One of the first things that she needs to do, that she really needs to talk with the parents. Sometimes they're more helpful than she really thinks they're going to be. This is the next thing that has to do is to get counseling. Planned Parenthood, or the organization that can do that, she's got to do that. Then after she does that, then she can file a petition to have the judge give consent. This advocate mischaracterized the key purpose of the bypass. After all, the point of the bypass options is to give minors an alternative to parental consultation. And unlike 2 similar cases described in Chapter 3, this advocate did not correct the mistake. This advocate compounded the mistake with 2 additional errors. First, she failed to point out that the court would supply an attorney to guide the minor through the process. She said that with respect to filing the petition, an attorney is not required to help her do that. It's fairly simple, and she would have to fill it out by herself. When pressed on whether the lawyer would help, this advocate replied, no, that's not something she can do herself. Second, the advocate did not indicate that she herself would be available to assist the minor. Instead, she referred to the 800 number established by DCF. I think this phone number may also give you some options for counseling services. The advocate remarked, it's 800-435-7495. I've not called the number myself, but that number should be able to refer to counseling. This advocate did not seem to understand that the hotline is designed to link minors up with advocates, and that calling that number would result in a referral back to her. Adding insult to injury, most of the ignorance that surfaced during the above reported phone calls seemed innocent and not intentionally hostile or malicious. Many respondents tried to provide guidance, looking up phone numbers of possible leads, or asking for additional time to track down information. Several apologized for the lack of experience. In some instances, however, respondents who proved poorly informed about the bypass option indicated hostility to abortion or opposition to the prospect of avoiding parental involvement. One juvenile court employee in Tennessee followed up her guess that an attorney would have to be consulted by asking whether the minor had prayed about this. She ought to, the respondent continued. She may live to regret it. Seriously, as a person that doesn't believe in God, some respondents focused on the physical risk associated with abortion. The attendant needed to involve parents, as did the Tennessee court employee. We've never done that. The judge isn't in this afternoon, and I don't know whether he would be if something who's going to be responsible. You see that? The court's not going to take responsibility if something happened. That's the only thing. I don't know what you do with that. Similarly, the Alabama court employee said, that's going to be the kind of tough to do. I think you probably need to talk to an attorney and he can bring you to the court's attention about what the girl wants to do. But I would say an abortion is something that the parent needs to know about. What if the first thing she needs to do is she really needs to talk to the parents? Sometimes they're much more helpful. The parent needs to be. I think that it's best to talk it over with the parent. Regardless, the girl will have to live with the situation from this point forward. If something happens to that child they don't know about and the death as a result, how would that be? From Alabama court employee, we heard this. Honey, I have no idea. I just have no idea. I feel like you don't. I feel like I don't believe a judge or even a lawyer would actually do it. It would be best to talk to your parents, because if this court does something that is just my opinion, and then how I would feel, I would not sign papers without parents knowing about it, because if something happened to that minor, the parents would know, and they would sue the court or the state of Alabama. I don't feel a judge or lawyer would do that for a minor. I can't say whether they would do that somewhere else, but I don't believe it would be in the best interest for a judge or lawyer to make consent like that without the minor's parents knowing about it. What if the doctor cut her somewhere and she bled to death that they could then sue? So, baby, I don't know what I'm going to tell you. I really have no idea. That I wouldn't want to be in the middle of. Others offered more personal and passionate lectures on the need for parental guidance, as did this Pennsylvania court administrator. Any person will want to know why the person will not tell her parents. I think this person should tell her parents, and you think that she will do this without the parents finding out. I don't know how that can happen. I would strongly suggest that you talk to this person and tell this person to tell their parents. This is not something that person should be doing as a juvenile without consulting someone who knows. Adoption agencies, it was a mistake. It was a mistake. It wouldn't help having a person make two mistakes. There are some numbers: Action Line for Life, Bright Light, Family Planning Clinic, Family Service Agency. I would strongly counsel this person into finding out before resorting to that. As a father, I'm telling you, there's a lot of people that can help before that decision is made. The person better know everything. Why some court employees shared their own opinions about abortion or avoiding parental involvement. Others spoke on behalf of judges. One Tennessee court employee said, "I don't know if that's even possible. I don't know how it would be possible to get with our judge. He wouldn't even sign for a juvenile to get married, but even with parental permission. So I don't think he would sign for that." One court advocate in Tennessee who made notable errors in conveying details about the bypass process also made discouraging comments about the prospect of securing a waiver of consent from some judges. Some of the judges in the smaller counties sometimes do, but not to do that. I'm not saying they won't do it, but they don't like to do it. So it might be easier to get the judges in some of the larger cities where the abortion is going to be performed to do it. Some of the judges themselves affirm that the above cited speculation about judicial attitudes. In one case, a woman in Tennessee judge's office attempted to get information about the bypass process from the judge, but did not succeed. She explained that she gave the judge a note asking him for information, but he hasn't answered it yet. I think that's something that's hard for him to do. After we called back several times and still failed to get an answer, the woman ultimately put the judge on the line, at which time her speculations about his reluctance were borne out. Taking a notably severe and insistent tone, the judge demanded the name and location of the caller, saying, You're going to answer my questions, ma'am. There's going to be a whole lot of personal information requested if you're asking for an abortion. The conversation proceeded in this fashion. Researcher, I'm just trying to find out information. Judge, I'm not going to sit here and tell you all about that information on the phone. I'm just not. You can go to a juvenile court and request the documents that are required. I'm not going to talk to you and tell you the whole scoop on the phone. You need to talk to a lawyer. So this whole process, would it be taking a long time? I didn't say that. It wouldn't necessarily take a long time. You need to come to the clerk's office and request those documents, and they will give them to you. You mentioned needing a lawyer. Well, the forms we have on the state have a place for lawyers to sign. So researcher, so a girl, she would have to pay for that. See, you're asking a bunch of questions that you're asking on the phone, and I'm not gonna get into the whole scoop on the phone. That's not what I do. If she wants to do this, she has to come down here. Another notable exchange emerged after an initially responsive woman, this time in the judge's chambers in Pennsylvania, sought to learn about the bypass process. I've never been asked that question. I'd like to ask one of the judges, why don't we call you back? When she did, she reported that she had talked to the judge. She gave a statement, which I'm going to read. The statement says, "This court will respond to an application filed for any matters in accordance with the law and rules of civil procedure. So long as the proper paperwork is filed, the judge would at least review it." She proceeded to explain, however, that she did not have the proper paperwork and that she was unsure whether paperwork could be obtained or whether the lawyer would be able to provide it to assist. But she said, if you can drop the paperwork yourself, a lawyer might be able to help. I talked to the judge, and he said that we've not had this incident. He said you should try to call the Pennsylvania Legal Services and tell the secretary that the judge requested you call them. After some additional pressing to obtain further information, the judge put the judge on the line, and this is what happened. We need your name, your phone number and name. We really can't handle this information without this. I don't intend to handle it. I'm going to recuse it. Do you know what that means? I'm not going to handle the case. I'm going to hand it over to the APOC, the Administrative Office of the Pennsylvania Courts, and they'll find a judge who will handle it. We're going to research it. I know about this law, but I don't know about this law I know about this law, but I don't know about the law specifically. I personally won't handle it. I don't know if the other judge will. I will recuse it. But I have to have some information for you. We'll have to conduct a procedure to see whether we can conduct proceedings. We'll do what we can. We'll check, but we need to contact you. I don't like doing stuff secretly, but that's not the nature of our legal system. Our legal system has rights, and people are supposed to know when their rights are infringed. They want me to authorize this kind of procedure. I took an oath to uphold the law, and I will. The judge clearly did not identify to whom he was referring in saying people are supposed to know when their rights are informed. But however, given his reservations about secrecy, his comments about recusal, and the harsh tone, it's reasonable to conclude that his concern lay not as much with the right of the pregnant minors as with the right of the minors' parents. Conclusion: some 51% of the courts in Pennsylvania, Alabama, and Tennessee proved absolutely or materially ignorant of their responsibilities under the state's judicial bypass provisions. The deficiencies in Alabama and Pennsylvania were present despite the fact that these laws in the states had been in effect for some time when this study was conducted. In Tennessee, the deficiencies existed despite the fact that 96% of the state's courts had recently and explicitly acknowledged their responsibility under the law. The courts should be able to rehearse relevant details of the bypass process when queried. When agents of the court deny the existence of such a process or propose the means of skirting the involvement mandate, such as traveling to another state, they transparently violate any reasonable expectation about how the bypass process will function. The failure of respondents to communicate information and about availability and terms of legal representation is an extremely serious matter. If a minor were to confront court personnel who confess ignorance about the bypass process, she would have every reason to be discouraged about the prospects of continuing pursuit of a bypass. But a minor who knows that she is going to get an attorney is very likely to have confidence that her request to obtain a hearing will be successful, even if court personnel prove otherwise uninformed. Indeed, conveyance of information about court counsel is by itself enough to overcome most other errors and omissions that may be made by other respondents. Failure to convey this information makes it appear that the minor, without the wherewithal to find and hire an attorney, would have to navigate the bypass process completely independently and on her own. This is unacceptable. At the very least, a minor is entitled to know that there are circumstances under which she will receive court-appointed counsel and what those circumstances are. Even if a minor secures the services of a private attorney in the face of misinformation about what she's entitled to receive, this still runs counter to our conception of how the bypass process works. The state has no less failed in carrying out its obligations simply because it has encountered a minor with means sufficient to overcome that failure. Court personnel who made referrals to abortion clinics, crisis pregnancy centers, Catholic charities, the health department, and so forth did so without knowing whether those referrals would prove useful, did so with good intentions. Those intentions notwithstanding, in most cases, these recommendations led to dead ends. Even in the fortuitous instance when a blind referral leads to discovery of accurate information about obtaining a bypass, this accident should not engender confidence in the process. Consider that while most abortion clinics in Alabama, Pennsylvania, and Tennessee are familiar with the bypass option, their familiarity is typically limited to the procedures and the counties where they are located, and thus, while a minor may discover useful information when she contacts an abortion provider for family planning organization, she may be directed to the juvenile court system in a county other than her own, left unaware of her entitlement to file her petition in her home county. Moreover, even if a minor were to find her way to a bypass hearing in her own county, following the blind recommendation to contact an outside agency, that outcome should not lead us to think that the law is functioning properly. We are entitled to expect that those charged with implementing the government's regulations will be able to do so. As a court that offers blind recommendations fails to discharge its responsibilities and simply shifts the responsibility elsewhere. This failure is not mitigated by the consequent actions of the regulated party or the purely voluntary behavior of private citizens or non-state institutions. These cannot be surrogates for a well-functioning government. Not all information about how the bypass process is of equal value or the initial quest to obtain a hearing, and we have seen cases of immaterial errors and omissions. However, it is not that the bypass process, it is not it is not enough for the courts merely to keep the door to the bypass process unlocked or slightly ajar, allowing entry only if the minor secures her own attorney, travels to another county, or creates a waiver petition by researching the local rules. It is all well and good for courts to acknowledge that the state has crafted an avenue for minors to petition for a bypass of parental involvement, but access to bypass must be reasonably achievable and unimpeded by the court's miscommunication about the law. The comments that portray personal or political bias against abortion or the bypass option were made in the context of otherwise unacceptable responses, but they nonetheless magnify the impropriety of the interaction. It is one thing to be told that there is no such thing as a bypass, and another to have the information accompanied by an angry or hyperbolic lecture from a judge or court administrator. The chances of a minor of overcoming polite ignorance would seem to be greater than those overcoming bombastic incompetence. Moreover, the comments provide a window into the real-life difficulties of implementing a policy with recalcitrant actors. The judicial bypass process is supposed to protect against the unacknowledged ills of acknowledged ills of the parental veto. But the palatability of the bypass compromise depends on the nature of the material reality that purports to instantiate it. And in this chapter, as we have seen, that those charged with implementing the compromise are very often woefully and wholly incapable of doing so. So it is for this book. You know what? You want to know the case against the damn thing? Read the book.